One, if we could keep everything down, please. Welcome to the December 21st 2017 Zoning Board of Appeals. I'm not sure, we only had two matters on tonight. One of is getting continued, so we'll do that first. So if anyone is here for that first one, we'll tell you when that's going to be heard.
14 and 16 Old Country Way, LLC, of 14 and 16 Old Country Way, Scituate, requests a finding in accordance with Scituate zoning bylaw, sections 820 and 950.2, 520, and MGL Chapter 40A, Section 6, and/or any other relief which the Board of Appeals may grant to change, extend, or alter the pre-existing non-conforming use of the maximum impervious area at 1416 Old Country Way in Scituate, Assessor's Map 49, Block 2, parcels 56 and 57, which presently contains two separate single-family dwellings and accessory structures to a use which will not be substantially more detrimental to the neighborhood, and which will contain less impervious area, and two buildings containing allowable commercial uses in the business and water resource protection overlay zoning districts.
Okay, let me just tell you what's going on with this application. I happen to be a direct abutter to that property, so I have to recuse myself. Mr. DeLisi, who is Attorney DeLisi, who was going to be representing the applicant, had a conflict tonight, so we were looking to move that to the January meeting. But since I'm going to be recusing myself, and we are down a member, it's very important that Mr. Bucari was available. He is not available in January. So by agreement of the parties, that application has asked to be continued to our February 15th, 2018 meeting. And we do have a letter to that regard? Okay. Do we have a motion?
Move to postpone the application to be heard on our regular meeting of February 15th, 2018.
Second?
Seconded.
All in favor?
Aye.
Okay. So if anybody was here for that, it will not be heard tonight. We'll move on to the only other application tonight.
Attorney Frank Middleton, Jr. of 80 Washington Street, Suite C20, Norwell, as attorney for Teresa A. Nielsen of 106 Stockbridge Road in Scituate, Massachusetts, requests an appeal of the permitted use at 161 Driftway in Scituate, Assessor's Map 59, Block 1, Parcel 2C, for enforcement under MGL Chapter 48, Section 7, and Scituate zoning bylaw, Sections 490 and 450.3.
Okay, and is it agreed that the correct address is actually 161? Is that what I understand? Or is it 167?
161.
161. Okay. Hi.
Hi, Frank Middleton for the record.
Attorney Middleton, would you like to give us a description of what this appeal is all about?
Yes, Madam Chairman, let me just start by giving the board a couple documents that I think are going to be helpful. This is, for the record, an internal memorandum from Neil F. Duggan, the Building Commissioner, Zoning Enforcement Officer, dated July 21st, 2010. We received this memorandum pursuant to a public records request. I think it frames the issue and also sheds some light on the fact that this zoning issue, a zoning violation, has been known to the town for some time, and it's unclear what, if anything, has been done up to this point. But I thought the board should know that this is not the first time, apparently, that it's been on the radar of the zoning enforcement officer. For the record, I'll just read into what Mr. Duggan indicates, and this is a memorandum to Patricia Vincisi, Town Administrator. Mr. Duggan states basically, and I quote, Lopes, and this is an indicating Tim Lopes at Go Green, quote, "Lopes seems to be operating in violation of the terms of his lease. Page 6, Section 9, permitted usage, which states, quote, "The lessee shall be permitted to use the leased premises only as a yard waste composting facility and for parking and storage of the equipment for the purpose of conducting yard waste composting operations. The lessee shall not be permitted to use the leased premises for any other purpose," end quote. He states, ironically, while the landscape supply operation is a permitted use of right in the C-zone, the composting operation, as you point out, is not licensed, nor was it ever permitted by the ZBA or the planning board. Skipping to the end, he indicates to Ms. Vinchisi his recommendation, which is using the lease agreement as leverage, amend to allow Lopes to continue his landscape supply business on condition that he not use grinders, which in the first place is a manufacturing operation requiring permission from the ZBA, and limit his hours of operation to reasonable business hours, prohibit operations on major holidays similar to those observed by the transfer station. This is a memo in response to a letter from Tanya Trevisan, who's an attorney for Mark McKeever. I also received some documents indicating that Mr. McKeever, who's an abutter, who's also a member of the Driftway Conservation Group that I represent and signed the petition that I presented to the zoning board, had an issue right off the bat with Go Green involving noise, dust, and other problems he was having as an abutter.
Okay, I'm sorry. When did you submit that letter to the zoning board?
Which letter is that, ma'am?
The one you just referenced.
Just now.
We're not on the same page. You said you submitted a petition to the zoning board.
The zoning board, in the application for the appeal, I included the petition.
Oh, I'm sorry. I did not get that.
Is this the
I
petition?
got the letter.
No, in the application that I provided, I gave 10 copies of a petition that has been signed by over 100 citizens of Scituate opposing the Go Green operation at 161 the Driftway. I also provided 10 copies of the lease agreement with the town.
Oh, well, I got the lease agreement.
Got the lease agreement.
Right.
Yeah, the petition was attached to all those documents, so it should
Okay,
have
I'm
a,
sorry.
it's just a list, just a list of names.
Okay.
Okay.
I can get you another one if you need it, but that was all part of the same.
I don't think I saw it either.
Yeah. Do you have a copy of that?
I should, yeah.
Fantastic.
I apparently got two of these, and I don't know whether they're one for the file, but
Yeah.
I do not have it.
No, it doesn't look like I have it either.
Sarah, I do not have it. It was not received. This is the
Yeah.
Could
copy of the application. do
I
not
can
have it.
provide it at a later date.
Could you perhaps tell us what it said?
The petition is a petition that was signed by citizens of Scituate on, I think, 5 different occasions opposing the operation, the composting operation at 161 the Driftway by Go Green.
I understand that was perhaps something submitted to the Board of Selectmen last year, or a similar petition?
Probably was, yes.
Okay.
So, but it was definitely submitted to the board as part of the application.
Well, Annie doesn't have it. I don't know what happened there, so,
I do not have it.
sorry.
No, that's all right. It
Yeah,
almost killed
I don't know
my
what happened
printer
there.
doing it, but that's all right. So,
She's got a copy.
thank you. All right.
Okay. Petition for attorney, I can't read that.
Attorney
Attorney General.
Oh, Attorney General of the State of Massachusetts, probably, I'm assuming? Okay.
I believe so.
Was there something filed with the Attorney General's office on this?
Not that I know of.
Okay. Driftway Environmental, against Go Green, Driftway Environmental Group, and there are a lot of signatures, I'll grant you this. A great number of them are totally unreadable, unfortunately, because of the bad copy. But, if you want to submit this to the board, I would ask that you just submit a clear copy. So it can actually be seen who's on here.
Sure.
Thank you. Want to see
Thanks.
that?
I'm good.
Okay.
So as you can see from Mr. Duggan's memorandum back in 2010, the main issue is what the acceptable use of that particular parcel of land is. And if you look at the zoning bylaws, and I did some research with case law today, what the board has to do, and what the court may have to do at some point, is interpret, of course, what the legislative intent was of the authors of bylaws, for the most part. In an attempt to kind of aid the board in that, I also received, and I have a copy that I provided today for the record, an email from Mr. James Hunt, who was a member of the planning board back when the Plan Development District was authored and voted into existence at town meeting.
Did we get that?
Yeah, that's attached to what I just gave you.
Oh, you attached
Yeah, I'm
what we
sorry, it's
just
the
gave us.
last page.
Okay, sorry. Okay.
And with respect to trying to determine what the intent was with respect to the bylaws, I think Mr. Hunt helps us by, and I'll quote what he wrote. He indicates, as a principal author of the PDD amendments voted at the 1992 annual town meeting, I can state unequivocally that it was never the intent of the planning board that the PDD be used as, quote, an overlay district. After all, doing so would largely nullify both the intent and most of the specific language of the uses permitted in the various PDD districts. Subdistrict F, marine and residential, is a good example with specific language concerning commercial uses within that particular subdistrict. The lack of similar language in any of the other PDD subdistricts, including Subdistrict E, should be evidence that commercial uses as of right were never anticipated in those subdistricts. Whether or not GG Go Green was granted a special permit with restrictive conditions to operate a commercial or industrial enterprise in Subdistrict E should be a matter of record, but I have no direct knowledge on that. And I think it's important that that the board look back to try to determine, not only from the language in the bylaws, but from people like Mr. Hunt's input, what the intent was at the time 490 was placed in the bylaws. As I indicated in the letter to the zoning enforcement officer, what we're looking for, what this group is looking for, is enforcement of the zoning bylaws. And I think if the board looks at it like the court looks at it, which is in a common sense approach, looking at all sections, reading it in a comprehensive manner, you run into the same issue, a same problem I would suggest that Mr. Hunt had, and the same problem that the former zoning enforcement officer, Mr. Duggan, had, which is you have a real conflict between what's written in Section 300, where it says that the Plan Development District is an overlay district, and then the actual language in Section 490 defining the Plan Development District. If you look at the language in the Plan Development District, it is unambiguous, it is clear, and it tells you in no uncertain terms what the purpose is and what the permitted uses are. I think the purpose is pretty clear to anyone from Scituate who is familiar with the Driftway and sees it as kind of the main thoroughway into downtown. People want to keep it looking good. They won't know it's an entry focal point of visitors and commerce. In the bylaw, it indicates that the purpose of the PDD is to encourage a mix of land uses and activities, including a golf course and community recreation complex, a mix of residential land uses, including permanent affordable housing and building types that complement each other, to provide for the development of these uses in a comprehensive manner instead of piecemeal, to save open space that otherwise would be lost or wasted, to promote more efficient use of land while protecting natural resources such as wetlands, water bodies, groundwater, and native vegetation. That's the purpose. And then they go on to indicate in 490.2 the permitted uses in the PDD, and there are only 4. They indicate in subdistricts A, B, C, D, E, and F in the PDD district, the following uses are permitted as of right. A, uses permitted as of right in the floodplain and watershed protection districts. B, religious and public educational uses, agricultural uses permitted as of right in the residence districts. And C, municipal water supply and wastewater treatment plant facilities. D, In Sub-District B, all of these uses permissible as of right in an R2 district, subject to the same conditions and procedures therein specified. They go on to define uses permissible by special permit by the planning board. Again, this is where Mr. Hunt comes in play as a member of the planning board. As he points out, they went to great pains now to outline what the planning board would allow people to do within the planned development district. And I know that you have this in front of you, and I don't want to read everything to the board, and I don't want to take up too much of the time, but I think since the response from the zoning enforcement officer was very simplistic, which is basically the planned development district is an overlay district. It's on top of a commercial district, therefore, everything allowable in a commercial district is allowable. Therefore, the Go Green retail operation is allowable because it is in a commercial district. That's the response of the zoning enforcement officer. That is the response that we are appealing, and that's the response that I think is faulty. I understand where he gets it. I understand that reading Section 300, where they talk in terms of naming it as an overlay district, that on the one hand, that makes sense. But when you read in a common sense fashion, and if you read it like the courts are going to read it, you have a huge conflict here, meaning 300 does not match up to 490. Section 490 is very clear, very unambiguous as to what the authors of these bylaws wanted to go on in the planned development district. And clearly, it wasn't a commercial use outside of the limited commercial use that they carved out of Sub-District F. This particular parcel, where Go Green is leasing property from the town, is in Sub-District E. As I point out in the request for enforcement, Sub-District E only allows for one simple use. It's a wastewater treatment plant and water for the town. That's it. That's all they carved out for Sub-District E. As Mr. Hunt pointed out, Sub-District F has one section where they allow for some commercial use, but they also make it clear that that use is only permissible by special permit. And they want people to go to the planning board, they wanted to control development, they wanted to save open space, they wanted to protect the resources of the town, and they wanted people to go through the planning board. None of that has happened. We've made repeated requests for any and all special permits, variances, anything that Go Green has received from the town that allows it to operate not just a industrial composting operation, but allows it to operate a landscape retail business, which I think everyone agrees, even the zoning enforcement officer now agrees, is a violation of the lease. This is from the response by Mr. Vogel. Again, I respect his position because he is relying on one section of the bylaws. Unfortunately, his response ignores the main section of the bylaws that I think is controlling, which is 490. But he also indicates that other, and I quote, "Other issues raised by your letter are deserving of consideration, to be sure. I know from conversations with Deputy Chief Al Elliott that the fire department is concerned with the bulk and height of the mulch piles, which can generate temperatures high enough to cause spontaneous combustion." I would point out to the board that not only is it enough to cause spontaneous combustion, it has caused multiple fires to the tune of close to 2 million gallons of town water spent extinguishing fires between 2012 and 2016 alone. We requested fire department records, and I spoke to Deputy Chief Elliott myself. To say that the fire department is concerned is a little bit of an understatement, and to say that the town is bleeding money to put out fires caused by this operation is an understatement. 2 million gallons of water in that 5-year span alone. And that's not even considering the risk to the health and safety of the firemen who had to go there on dozens of occasions to put out fire after fire after fire. And on some of those fires, the composting material was so high and had basically breached the fence lining its property that they couldn't get behind it to put out the fire and had to get on the other side of the fence. Deputy Chief Elliott was concerned about that and said he did take steps to make sure that at least there were pathways between the mulch so that the fire department could safely get in there. I also, with the application, gave an aerial photograph of the property for the board to look at because although I know it's a position of Mr. Vogel that zoning doesn't really have a say in whether or not this lease has been violated. I think the board should see that what's being done on this parcel isn't simply a composting operation. Go Green Landscape Supply is also storing and selling firewood, massive piles of firewood, which again, I don't think you really need to be an expert to put two and two together there when they're having repeated compost fires, but right around the corner from the fires, they also have massive piles of firewood, which they sell out of that location in violation of the lease. They also have a trailer there that has been there from essentially its inception, that's up on stilts. I received no permit for that. I see no special permit or any type of authorization from anybody in the town of Scituate for a permanent trailer to be used in a retail operation. The lease doesn't mention the right to put up a building or put up a trailer. It says simply that you can run a composting facility and park trucks there to run the composting facility, period. If you look at the Google Earth photograph that I took off the internet, and you can do it daily, you'll also see that there are piles of, I'll go from Go Green's own flyer here. They also, besides mulch, they're selling stone products out of this location as well. Stone dust, crushed stone, crushed run, sand, wash brown, pea stone, and cobblestones, all visible from any aerial photograph that anyone can check on a daily basis. Big, massive piles of these items are kept at 161 the Driftway daily. Again, in complete violation of the lease, and I would suggest in complete violation of the zoning bylaws, that nobody has authorized this use in this subdistrict. I'd also suggest that the response of the zoning enforcement officer, again, is overly simplistic. He basically just says, well, it's a commercial district, so you can have a commercial use. But when you look at the uses enumerated in the town bylaws, they have all the commercial uses that are enumerated, and none of them are a compost facility. None of the industrial uses enumerated are a compost facility. And a compost facility, as we all understand, is kind of a specialization, because you're talking about grinding up all kinds of matter, leaving it in huge piles, then grinding it into mulch, dyeing the mulch certain colors and selling it, all for profit. And that's the other thing that I think the board needs to consider. This idea that this is somehow a public use that is benefiting the town or people of Scituate is a fallacy, and that was a reason for the zoning enforcement officer's rejection of our request, is that this was a public use under section 450. Again, I think factually that's not supported. This is not a public operation by any way, shape, or form. There's no case law that I could find where a private corporation running their own business after leasing it from a town was considered, quote-unquote, a public use. There is no public use. The public gains nothing from this operation. This is a for-profit corporation, and the only thing the public is remotely getting is the ability to bring brush and yard waste to a location, have it ground up, turned into mulch, and then having it sold back to them or sold to others. That would be the good side. The bad side is, of course, composting operation is required to adhere to the provisions of the DEP. And again, looking at those photographs, I know they're not to scale, it appears that that operation is not complying with any of the requirements of the Department of Environmental Protection. Again, does that affect the zoning board? I suggest it does. I think every violation is important with respect to how you decide this, because ultimately, if there's a zoning violation, and the zoning violation is putting people in potential danger of harm on a number of fronts, not just abutters' right to enjoy their property, but dust, smoke, fire, traffic, huge trucks going in and out at all hours, the same types of complaints that Mr. McKeever made years ago continue today. The DEP regulations require and mandate for very strict adherence to environmental concerns when running this type of operation. Piles of compost are only supposed to be 30 feet high. They're only supposed to be certain amounts and lengths and widths. There is no way, judging from those photographs, that Go Green is adhering to any of the DEP regulations. And reading through the fire department records that I read through, it's clear that these piles are way above 30 feet. It's clear that they're creating a public hazard, and they're creating a danger to the firemen who have to go there to put out these fires. But that's just one issue. I think the main issue, as I say, from a zoning perspective, and we just finish up with Mr. Vogel's last comments. He also indicated that the cost of department response and of water to extinguish the fires is indeed high. The amount of material on site similarly concerns the Conservation Commission. Pat Galvin, the former conservation agent, who has recently been replaced by Amy Waukee, has repeatedly expressed the opinion that the operation is encroaching on the surrounding wetlands and should be controlled. The dust and odor, if it is serious enough to cause health problems, is a matter to be brought to the attention of Jen Keefe, the town's health agent. As for the sale of landscape supplies other than mulch, I'm told this is not covered by the contract between Go Green and the town, which restricts the operation to, quote, compost, actually mulch. So this indeed is an infraction, although not against zoning. If your clients wish to pursue these issues, I suggest the proper officers be contacted. Again, I appreciate his honesty in recognizing all these issues, but I disagree that it's not a zoning issue. It is definitely a zoning issue, because this business is only being run because zoning is allowing it to run. And unfortunately, zoning is allowing it to run in complete opposition to its own bylaws. Just, for example, Section 490 goes to the trouble of breaking the planned development district up into 5 different sub-districts, A to F. A is the Affordable Residential Housing District. And it goes to great detail as to what the goals and how they would like that accomplished, and how the planning board will require special permits and everything to be done according to all these restrictions. There's no reference in there, once again, that you can put up any commercial building because it's in an overlay district. Subdistrict B, open space, residential and recreation, once again, talks about a golf course, talks about a country club. No mention of commercial use whatsoever. Subdistrict C, this one's interesting, is conservation. Uses in Subdistrict C shall be restricted to those otherwise allowed or permitted in Section 460, which is the salt marsh and tidal conservation districts. Additionally, the following uses may be allowed by special permit after review and comment by the Conservation Commission: boat launching and associated vehicle parking, and other uses similar in function designed to those in 460. Section 460 notwithstanding, the planning board shall be the special permit granting authority in Subdistrict C. So if you take the zoning enforcement officer's position, Subdistrict C is also in an overlay district, and therefore anybody could open up a commercial enterprise tomorrow without any oversight by the planning board, without any permit whatsoever. And clearly what they're trying to do is protect the resources of Scituate and make it conservation-based on Subdistrict C. Similarly, Subdistrict D is a water resources. After due consideration of the recommendations of Mass DEP and subject to planning board approval, public recreation activities may be located on this parcel. Planning board shall ensure by permit considerations such activities will not harm the quality or quantity of the water supply from the public well in the subdistrict. Again, if we take the position of the enforcement officer, Subdistrict D is also open game for any commercial activity because it's in an overlay district on top of a commercial district. I don't see how that makes any sense, and I don't believe the courts are going to see this conflict as making any sense. Subdistrict E, the district that the parcel is in, says simply, again, municipal wastewater treatment facilities may be located in Subdistrict E. The response from the zoning enforcement officer was that his interpretation was different, that that was not the only allowable use, that the uses permitted by Section 492.2 within the PDD and the reference subdistricts A through F are in addition to the uses permitted in the underlying commercial district. And he actually says an example can be found in the PDD Subdistrict E wastewater treatment you reference in your letter, which states, quote, as I just stated, municipal wastewater treatment facilities may be located. While you interpret this language to mean wastewater treatment is the only allowed use, my interpretation is that this is an allowed use that is additional to the uses allowed in the underlying commercial district. As you can see, that just doesn't make any sense. It would completely nullify all the work that the planning board put into the planned development district. the mixed use, the protection of the resources, protection of open space, protection of the environment. It would be a pointless exercise if commercial enterprise was allowed across the planned development district only because it's in an overlay. And here's the other important point I think that the board needs to consider. When you look at the language, and the courts and all the case law on point says that's what you need to do. You are in fact the judges of this particular issue. So to make your determination, you have to look at all the language in the bylaws and look at it from a common sense and comprehensive standpoint. Look at Section 500, because Section 500 is named special districts. And in Section 500, they actually have 3 special districts. It's the only time you see the word overlay. Section 540, 560, and 570. These are the 3 districts particularly named as overlay district by the bylaws. And one thing that's consistent in all the quote-unquote overlay districts is that the first thing they tell you, the first number out of the gate is permitted uses. And it's the same language in each and every one of them. Permitted uses include, quote, all uses permitted in the underlying zoning district as a matter of right. So those overlay districts, the bylaws are very clear on. All the uses in the underlying district are permitted as a matter of right. That language appears nowhere in 490. That language appears nowhere in the planned development district. I would suggest to the board that that is the critical piece of evidence. They left that out, and in fact, that language would make no sense. It defies comprehension as to why they would allow any commercial activity as a matter of right after putting all these restrictions and all these special procedures and requirements for special permits to do anything in that district besides those 4 enumerated uses as a matter of right. That's pretty much everything I have. I mean, I would suggest to the board, as the judges of the facts and as making the determination as to whether or not these are permitted uses, I think all of these factors are important, but the main one is the construction of the bylaws and the legislative intent. And you've heard now the intent of one of the planning board members who was the author of this particular plan development district. I think the plan development district language speaks for itself. There's no way it can jive with being an overlay district. I think the decision of the zoning enforcement officer is not based on fact or on law. It is incorrect, and I think the use of that parcel of 161, all the information I had was 167. That's why the wrong address was on there. Everything from all the paperwork I received said 167. He identifies as 167, but apparently 161, the Driftway. Clearly, the only use allowed on that parcel was for wastewater treatment. And you may ask the question, well, why just one use in one section? And again, I think that makes perfect sense. The authors of this plan development district didn't want any interference with a very important municipal function. They wanted one thing done on that particular sub-district parcel, a municipal wastewater treatment center. That's it. They didn't want a bunch of commercial operations around it. And I would suggest the last thing they would want in close proximity to your wastewater or treatment center, your water supply center, is a composting facility, which, excuse me, as you can see, is getting bigger, not smaller. That this company was given an inch and took a mile, essentially. They were given a lease to do one thing. Now they're selling pretty much everything under the sun out of that location in complete violation of the lease, and nobody seems to care. The lease is being violated, but more importantly, they're encroaching on the environment, they're encroaching on the conservation land, and God only knows what kind of damage the runoff from black dye is doing into your water supply, is doing into your marshes, and is doing into the North River. I think, again, the authors of this bylaw wanted the Driftway area to be open. They wanted it to be attractive. They wanted this to be the gateway to Scituate. You've got bike paths, dog walking areas. It's a nature paradise down there on the North River. But, it's incomprehensible that in that environment, anybody any right-thinking person would want this industrial composting activity to go on, which is not environmentally safe. It's not safe to the neighbors. It is damaging to the air. It's damaging by way of, public safety, and it's damaging to all the abutters in that area's right to have, make full use of their property. So I'm going to ask that the Board of Appeals overturn the decision of the zoning enforcement officer. I'd ask you to base it strictly on the language of your own bylaws. This is not a use that is a matter of right in that section, and I would suggest it's not even a commercial use that's allowed. He would need a permit, even if you find that commercial use is somehow allowed, it's not an enumerated use, he would need a permit to do it. There is no permit, there's no special permit, there's no variance that's been granted. It strictly was done as a lease. I would suggest at this point it violates the bylaws and needs to be stopped.
I guess that was my first question, was going to be, what's the remedy you're looking for?
Enforcement, it should be stopped immediately.
So close down,
Or
close,
move to an area where it's allowed. I mean, it has to be moved out of the planned development district because it's not in an enumerated sub-district. It's potentially allowable in sub-district F, which is next door. But, again, it would require a plan to the planning board so they could control any possible environmental consequences or any damage to any of the abutters. I mean, nobody, the way this was done, nobody was given an opportunity. It was strictly a lease, and that's it.
leased by the selectmen.
Exactly.
Right. So again, your goal here is to get us to close down Gold Green.
Yeah, we're simply asking the town to enforce its own bylaw. I think the bylaw is very clear. I think the intent of the authors of the bylaws is very clear, and we're simply asking for enforcement. And
can we agree your client is not an abutter to this property?
no, we can't.
We can't agree?
No, my client is the Driftway Conservation Group, which I've indicated is encompassed dozens of people, including Mr. McKeever, who was an abutter, who was the first person who complained about Go Green.
Sure.
I don't know what I did with it. It's right here somewhere.
Here's our...
That's the wrong one.
I have the wrong one.
Right.
Here's the,
I have like 60 million documents here.
Sure I have it.
Probably underneath here.
Here we go. On behalf of Teresa,
Right.
I can't make out her last name.
Nielsen.
Teresa Nielsen
Right.
of
Right.
800 Washington Street in Norwell.
No, that's my address.
What is Miss Nielsen's address?
106 Stockbridge.
Okay, but the applicant's name is you, but on behalf of Teresa Nielsen.
Correct.
We know you don't live there. So it seems to me, your applicant, you didn't say somebody else, you said Teresa Nielsen is the applicant.
Yeah, that's a simple line on the, I am the applicant because I'm filing the application. If you see the letter I sent to Mr. Hallen, attached to that, it indicates that, on October 18th, 2017, a request for zoning enforcement pursuant to Mass General laws was made to Mr. Robert Vogel, Scituate Zoning Enforcement Officer, see attached letter. The attached letter and what
Says represent Teresa Nielsen. She's a member of group.
Yeah,
I'm a member of a lot of groups.
I incorporated the letter that this office represents Ms. Teresa Nielsen, a resident of Scituate for over 50 years and a member of a concerned citizens group, the Driftway Environmental Group, who oppose the operation of Go Green Landscape located at 167 the Driftway.
Well, I think if we've got a threshold issue.
I think I'm not sure Miss Nielsen's address puts her close enough to be the applicant of record.
Well, she is the
For this
applicant of record. So the question is, before we get to any of the other stuff, the question is really one of standing, as I see it. So the first question is, she's not an abutter, which is a presumed person aggrieved.
Exactly.
Okay. So what is the legal right that you are asserting has been violated on her behalf?
The legal right that I've asserted from the get-go is on behalf of the Driftway Conservation Group. It encompasses all those people, including Mr. McKeever, who is in a butter. I believe there's some abutters who are here tonight. So all those individuals signed a petition. I just happen to be hired by Mrs. Nielsen, who is a member of that group. I represent that group for this purpose. That group has filed this appeal. That group is the aggrieved party, and many members of that group are abutters. So
Well, I think we're going to have to
if it's
disagree
as sim-
on that one.
if it's as simple as who fills out the application,
So,
it would be denied once you heard Attorney Frank Middleton from Washington Street, Norwell, because clearly I don't live in the town and I'm not in the butter.
I think that's being a little
Obnoxious.
obnoxious. And yes, we have many attorneys come before us, but we're dealing with an attorney as a representative for an individual or for a group. And all representations to this board thus far have been that you are an attorney representing an individual who happens to be a member of a group. But that, I'm an attorney representing Ed Tibbetts, who is a member of the Teachers Association of, Massachusetts Teachers Association. I am a member, but are you representing the Teachers Association? Absolutely not.
So, just to backtrack,
Sure.
to have standing to come before this board for the type of application you're making, please correct me if I'm wrong or run astray here, one needs to be in a butter or someone representing an abutter.
No, you just need to be an aggrieved party.
You need to be an aggrieved party.
Correct. You don't need to be in a butter. A butter just gives you per se that you're an aggrieved party.
Well, and I don't disagree with that, but I've got
So you're
I've got
aggrieved
Brodbowski
because
here.
your client who is on this application lives in town, and that is...
No, that would not just lives in town, but much like the 100 people that signed the petition, and much like the dozens of people who are a member of the group,
Right.
they live in town, and this is having a negative impact on their enjoyment of their property
Right.
and their enjoyment of the town. So they're aggrieved parties for that purpose. I don't want to,
Yeah.
I understand what you're saying, that there has to be some standing. My suggestion is that there's tons of standing. All these people are concerned, all the abutters are concerned, and this appeal was filed, and the request for zoning enforcement was filed on their behalf.
That might have been, well, I'm not going to agree with that one, first of all, but in general, if we assume that it was, they didn't file the appeal. Ms. Nielsen filed the appeal. And you have not articulated a specific peculiar legal right that has been violated. There is, if we're talking, and I know you've got, you've been around the block, you know what you're doing. That's probably not the best way to phrase it, but, I certainly looked this up, and Brodbowski says it's not enough to have a general civic interest in the enforcement of zoning ordinances. And you have not articulated a single peculiar interest, legal interest that of hers. Whatever you say doesn't matter. It matters what's on this. I don't really care. I don't know who Go Green, I don't know who this group is. I tried to find it on Google. I tried to find on Scituate Monthly. I'm not saying they don't exist. Anybody can gather and create a group and call themselves whatever. I don't know who's a member of them. I don't know. They're certainly not the applicant. And we don't know who they are and where they live and whether or not they're abutters. I just think you have a gigantic issue, an insurmountable issue for me about standing here.
Let me try to help you with it then, because I think you're oversimplifying the standing issue.
Everybody's oversimplifying in your book tonight, huh?
Sometimes it is what it is.
Yeah, no, yeah.
It's not-
That's what you say when you want to avoid the
It's
issue.
not simply abutters. No, I'm going to address the issue. The issue is Mrs. Nielsen or any member of that group an aggrieved party? And I would suggest I've outlined, and I can continue to outline, all the ways that this particular parcel and the use of this parcel is damaging the taxpayers and townspeople of Scituate. You already heard that the way that the parcel is being used is causing a massive usage of town water to put out fires. So that is...
Okay, let's start there, because I also happen to know that at least one of those fires is still being investigated as a suspicious fire and possibly an arson. So...
I didn't get any paperwork on that.
I'm sure. But nevertheless, I can reassure you that is. Now, Mr. Vogel represented that was a concern, and, you know, the reality of it is, he felt that it wasn't a zoning issue. It may be a Board of Health issue, it may be a fire department issue, it may be a Board of Selectmen issue, which I understand this group went before the Board of Selectmen last year, and Board of Selectmen apparently did not act. So, you know, now you come and you choose, or somebody chooses Mrs. Nielsen to come before us to complain again. This is, I would suggest, not an uncomplicated issue, but I'm not sure that it's an issue for this board.
So, just to add on that and to skip ahead maybe
Sure.
for a minute, let's put standing aside. I think that possibly if we talked about it for long enough, we could all agree that in addition to Ms. Nielsen, probably would have been helpful to your application to have someone who wasn't a butter also step up and put their name on the application. Let's assume that there's someone here willing to do that for a minute. Your fire concerns, I bet if we talked about those for long enough, everyone on the board would agree that those are legitimate concerns to anyone who lives in town or near it. But I have to agree with Sarah that that's something to be taken up with the fire department.
Right.
So I think that the issue that you have raised that maybe this is the appropriate place for is the use. And I might even agree with your argument that even though I think that there's some facts and things to be discussed on both sides, that this isn't an overlay district. I see your point. I think it's a pretty good one. What I want to jump to, and what Bob raised in his letter, was the public use issue, 450.4. The town had a composting operation. The town closed their composting operation and saw this as an alternative to that former town composting operation. The town entered into a lease with Go Green. You raised concern that this is for profit. I don't believe that the town had any thoughts or expectations that Go Green wouldn't try to make money as the tenant under this lease. They are paying a not insignificant sum for the site. They are providing a service to the town. The town had a facility that did this, that the town paid for and operated and maintained, and I'm sure insured. It no longer does. Now Go Green does that. They pay for the use of the land. I don't see anything in the lease that makes me think that the town didn't rightly expect that to the extent they could turn a profit from that operation, they would. You mentioned the trailer on the site. I can't imagine that the town had any valid expectations that they wouldn't have somewhere where someone could sit inside on the site in order to run this operation. So, to be honest, I don't see any reason to entertain an objection to the trailer. Your fire concerns seem legitimate to me. Your concerns regarding the landscaping supply. A good chunk of the property is used for what I see exactly what the lease was designed for. The lease says they can't do other things. There's sale of stone and firewood. There's absolutely an argument that those are other things. There's also an argument that your complaints about the site are really complaints about the public use that the site was intended for under the lease. And the environmental concerns and the noise aren't necessarily coming from them dropping off stone and selling it. And I could see them making an argument that that's one and the same. If a coffee shop sells donuts and the lease says it's only to be used as a coffee shop, it'd be hard to evict that tenant. But those are valid concerns, and if the group and the citizens are concerned that the sale of crushed stone or firewood is at issue, then I'd probably recommend that they lobby to the appropriate parties in town to not renew the lease when it comes up in June of 2019. Or that I struggle with if the stone and sale of other items is a true violation of the lease, and we're not the party to enforce that, who is? I sympathize with your point there, and that's a question I have. I just don't see how the town stops these guys from having the mulch and doing the composting. The town signed a lease with them some time ago for specifically that purpose. I don't see how you can make any valid argument that that's not a public use, and that, I'm gonna that 450.4 doesn't apply. I just don't see it.
I beg to differ, and I checked today, I looked far and wide to see if I could find a public use case where a town had leased out property to a private corporation who ran a for-profit private corporation, and any court of law determined that that was a public use, and there quite simply wasn't any. A public use is defined and interpreted in the common sense definition of public use. It's for the public good. It's not, it's a nonprofit.
You couldn't find an example of a town having some sort of lease for their waste treatment facility or their town transfer station to a company that turns a profit, and that waste treatment facility or transfer station wasn't necessarily within the allowed zone?
Not waste treat, clearly, the case law says that, running a transfer station is a public use. There's not one case that says running a composting operation is a public use. A dump or a transfer station is a public use. It's simple as that. This isn't a dump.
I'm able to go to Go Green as a citizen of town with a transfer station sticker and drop off any measure of natural yard waste. If that service wasn't available to me, I'd have to pay someone to come and pick it up and take it away.
And it was a public service provided by the town when the
Many
town,
years
when the
before
town
that.
decided to limit the use of space at the transfer station to do exactly that. They effectively contracted with Go Green under the terms of this lease to take over that responsibility as a service to the town.
But once it's privatized, it's not a public use. I mean,
That's an almost absurd argument
Yes.
to me.
Agreed.
Can't go there.
I can't even entertain it. There are, if a public service is provided, it doesn't matter if it's provided by a private company or not, and it doesn't matter if they turn a profit doing it. It's a public service.
I guess the big question would be what, there's some public service, some public right to dump your yard waste at a facility? Is that part of the town? But
I don't know if it's a right, but we've been given it. We've,
The town elected
I mean,
to
yeah.
do it through its elected officials, chose to do it. Matter of fact, I'll go back to some of the other concerns you've raised. You made an awful lot of very definitive statements that this is not an overlay district. Well, if you look at the town zoning map, it's listed under overlay
I did say,
districts.
yeah, section 300 says it is, and it's on the map, I get it.
I get
Well,
it.
I said I
So,
understood what Mr.
all right,
Vogel was saying.
If you were to take apart our zoning bylaws, and we have for years talked about trying to clean them up, we do periodically improve
But you
them.
just did.
But they're, the intent has to be considered. I have lived in the town for 62 years. I have attended town meeting pretty regularly. I would say probably over 80% of them since I was 18 and legally allowed to vote in this town. The Driftway area was not originally intended to be a gateway to Scituate. It was originally intended to be an industrial area for Scituate, a commercial industrial zone. In the early 90s, it was decided that this was an area that perhaps we could use what was then the Sand and Gravel Company, the Boston Sand and Gravel, as a municipal golf course. And it was about, my recollection, approximately a 10-year process of campaigning to create a municipal service there with a municipal golf course. I believe it was open sometime about 1996, 7, or 8, somewhere in that range. I'm just guessing. I'd have to go back and research it. But that was subsequent to an overlay district which outlined, this is the overlay district in question, which outlined, which I think was 1990, is the overlay district. Do you have that information when the plan development district went in?
I think it was around, according to the email I got, it was 92.
Okay, so
Voted in
1992,
Who knows?
approximately in that 10-year period when this town was campaigning, members of this town were campaigning for a golf course. It was a highly contentious debate, whether we needed a golf course instead of light industry. It went along the lines of a planned development district, which incorporated the opportunity to put the golf course in there. Frankly, I agree with the premise that this is a commercial zone. And under you might not be able to find landscape, treatment of landscape waste under the commercial zone, but I can find an awful lot of things that incorporate much of the same issues: noise, odor, structures like what was, you made a definitive statement that the trailer should not be on there. Why would the town in their lease have indicated that the lessee would be responsible for water, electric, and gas consumed on the site? I mean, you're not going to consume that if you don't have some sort of an office space to, or some sort of a structure in order to conduct a little business. The lease does allow for the storage and maintenance of vehicles. You can't really very well do storage and maintenance of vehicles without having some facility there. It does specifically say that no building shall be erected, but I wouldn't suggest that the trailer, as positioned on the lot, is a building erected. It may be a building, it may be, I don't know what I know we have regulations about trailers being put onto residential zones for living purposes, but I'm not sure that we're in violation there, and we may be. But I think really what you're looking at is a lease from the town for a commercial use on a site that is consistent with what the town intended them to do. There may be some violations of that, but as the leaseor, the town is the one that has to mediate whether or not they feel that their lease has been violated. And they wrote the lease. They intended to have something go on there. And to suggest that the fact that the Driftway is a gateway to Scituate, it may be today, and that may be where the town wants it to go, much the same as they did when they went from light industrial and commercial to an overlay district. But this tenant has a lease, and the leaseor is not here telling us that he's in violation of the lease or asking for enforcement. And it seems like it's coming from, I'm sorry, but a little out of left field. I appreciate that there may be many people in the town who are concerned, have concerns about the activity at Go Green, and if they want to approach the selectmen, as Anthony said, that makes sense to me. That's the way to go. And if the selectmen held an open hearing on whether or not Go Green or a landscape processing area should be allowed in town, I think you get an awful lot of people out to that hearing to say, you used to have it in the transfer station, you took it out of there, you put it over there, where are you going to put it? You have, we've gotten used to that as a town, a place to dispose of trash. We don't have the back 40 to put, the mulch and leaves and things from our yards. Most of us are on half-acre zones this side of 3A. It may not be a public service in your mind, but it certainly seems like it's servicing the public to me, and it's consistent with what the town had agreed to do, maybe passively, but at their transfer station, at our transfer station. And they appear to have transferred that responsibility to a contractor on town-owned land under terms of a lease.
And it's,
I'm just simply trying to clarify a lot of the blanket statements that I think you made, which I think were a little inflammatory, personally.
so,
I also kind of wanted just to, Ed just mentioned something coming out of left field. I'm compelled to address something that came to us this afternoon by email, which was submitted by Mr. Lopes. And I don't know Mr. Lopes. Is he here tonight? He's apparently not here, but he did submit a dozen or more reports from Scituate Police involving your client reports of everything from getting threatening phone calls from her, threatening emails. There's apparently a long-standing business dispute between the two parties. I'm not making a judgment on anything about that, but
You know what, while we're at that,
you're not being recognized yet, sir. But the concern I have is this is some sort of just continued personal issue between the parties. And the fact that a person who I believe does not have standing to bring this complaint, brought this complaint, makes me even more concerned that it is less sincere than one might think it is. I still go to, I think the case law on standing is clear. Your client doesn't have standing. Your client is not any kind of civic group. Your client is Mrs. Nielsen. She doesn't live anywhere near, she lives 1.5 miles from where this property is. She's requesting enforcement in a general sense. She has not articulated in either her application nor through you any kind of legal right. Now, you may be correct that eventually the Superior Court is going to decide that, and I think that they'll decide it first. They'll decide the issue of standing before they get to the merits, because if your client doesn't have standing, we don't get to the merits.
Can I just address the standing for the record? Just to
Sure.
make a couple more points. Much of, the majority of what I presented was based on standing. The damages to Mrs. Nielsen and any other taxpayer, let alone the abutters that live up and down the Driftway, is basically constituted of the increased taxes you're going to have to pay for the huge amount of money to the fire department to put out fires, the environmental damage that is being done to their community, even the noxious fumes up and down the Driftway.
That's not standing. If you look at the case law, that is not the kind of standing we're talking about. Her general issue with respect to she has to have a particular legal interest. You're talking about something much broader, and that's not, you're very good at criminal. I don't want to be on the other side of you when you were at a DA, but, this is,
Believe me, I understand your point, and what I'm presenting with respect to that issue is that it's not just merely, a civic duty type thing. She's indicated, as have the rest of the members, that there are damages being accrued, that this is something that is damaging the town as well as them as taxpayers. You've got increased costs.
Peculiar. Tell me about Mrs. Nielsen. What is her issue? Her distinct, particular issue? What are her rights that are being, her particular, not as applied to anybody else in the town, not as applied to all the people who might live in the immediate area? What gives her the right to come here today?
I think that's part of why we had a group of people that encompassed a standing issue. You've got the butters, you've got...
That here.
Yeah, that's why
You've got a
That's
specific...
why I presented that petition and put it in the letter, basically.
It's not,
Petition
though.
didn't come with the application, it's
Yeah,
come now at the
I mean,
11th hour.
I mean, to be honest, I might not feel as strong about standing as Sarah does.
I do.
But the petition is over a year old. It's barely legible. It's the Driftway Environmental Group. It has 2 lines at the top. I mean, we,
And it went to am I correct that you represented that it went to the Board of Selectmen prior to coming here?
Yes,
It was presented to
that's
the
what
Board
I
of Selectmen?
understand.
I believe you,
I didn't present it, no.
I
don't know.
thought when Sarah suggested, is this the same one that went to the Board of Selectmen? You
So
said
all
you believed
the,
it was.
all the public records requests went to the Board of Selectmen, so the public records requests had
But-
the petition in.
I think,
So they were CC'd to the Board of Selectmen, if that's what you mean, so they didn't,
I'm just saying, it's, to bring it to us at this point is a challenge, because that's not who is bringing this appeal.
I guess I'm trying to speak for the people that I've been dealing with, there is, a level of frustration, and I apologize if you sense some of that from me, but the problem, as I see it, and as many of them see it, is that it's kind of obvious that Go Green is operating outside the terms of the lease, and I understand that's an issue for the town. But to say it's not an issue for the zoning board is not accurate. I think the zoning board has a real stake in this, and the zoning board is the one, you're gonna go to the town, they're gonna say, well, it's a zoning issue. Go to the zoning board, it's not a zoning issue.
So
I haven't.
I'm prepared to make a motion right now that the operation of this site for composting, and I think that mulch is one and the same with composting, is not in violation of the Scituate zoning bylaw. I'm prepared to make a motion that we make a finding right now on that front, and I
Based on
think
public-
that some of my fellow members might agree with me. I think that if, especially, you mentioned something about the DEP regulating somehow the height of mulch piles for this type of operation, and it sounds like you have the fire department in agreement with you. That sounds like a great point, and it's something that I actually agree with. And if you had a petition going around to have the DEP and the fire department get more into it, I might sign it. I'm not sure that I, as a member of the zoning board, have any power to do anything about that.
Well, one of the things I want to do is let's hear from Bob, because Bob they're talking about your very simplistic response. Would you like to defend that?
I guess I'll start with saying I understand that the issues with Go Green, that there are some, and that they've been talked about tonight, and that it would be a good thing if some of the issues were addressed. The danger of fire, the water used to put out the fires, the possible encroachment on the wetlands, which is in violation of conservation, many things like that. However, I don't see any of those issues as being zoning issues. And I interpret this, as I think Mr. Tibbetts has indicated some agreement with, as an overlay district. And I interpret the uses listed in the table of use in the zoning bylaw to include several that address aspects of this operation, almost not quite, because it doesn't talk about mulch. By the way, I think there is a difference between mulch and compost, for what it's worth. Mulch is vegetative material only. Compost has waste in the sense of garbage and various things like that. I don't believe that's any part of this operation. If it were, that would be very, very not good. And so, but I think it's safe to say that only mulch generation is going on here. I simply don't see the possible lease violations as having a connection with zoning. You know, the very narrow issues of this board, and I can't speak for the board, but as a zoning enforcement officer, I enforce zoning. And so my opinion, and I'd be willing to have it looked at and decided upon by the SJC or any other body, but it's still my opinion that the use that's going on here, the principal use, does not violate the zoning bylaws of the town of Scituate.
Okay, thank you, Bob. Anything else right now from other board members? Nope. All right, so you've all been very good and patient. I know that at least some of you are probably going to want to put your thing on the record. So this is what we're going to do. I will call on people. You'll please raise your hand. Please stand. Please give your name and address. Nice and clear and slow so Annie can get it down. And would ask that, you know, people try to make different points each time. Please not to don't necessarily need to repeat the same points. But we're happy to hear if anyone in the public wants to make comments. Sir.
I'm Paul Nielsen with the Green Connection. I bidded on this project with Tim Lopes, and in the bid it said that whoever wins the bid has to go get their own permit, and so notifying the abutters, I want to see if Tim has notified all the abutters before he went into this project. I asked for engineering done, and this is what I got for his engineering, a little piece of paper with him. So, I mean, there was no wetlands delineations. I did a project in Hanover, and it cost me $50,000 to do my engineering with the state. So what I'm saying is that with the DEP and the town of Scituate, behind closed doors, rigged this little thing for Tim Lopes to get in here. We're not talking about, you know, piddly stuff. We're talking about millions of dollars here. And my goal is to sue the town of Scituate and go green for a loss of $4 million. And that's what I'm going to do. That's my plan.
Good luck to you.
Thanks.
Welcome.
Sorry, I didn't get your address.
90 Stockton Road.
Yes, ma'am.
Teresa Nielsen, Stockbridge Road. I've been there for 35
What
years.
was your address?
I'm living at 106 Stockbridge Road now, but I've been in Scituate since 1936. And yes, I do have a little bit against Mr. Go Green. He rides by my house and he mimics me and he smiles and he gives me this and that. Well, wouldn't you do something about it? He has ruined this town. Back in 2009, he said he was going to make a big win-win for the town. They were going to make lots of money, and it was a great profit thing, and the townspeople would be able to come in and dump their mulch, their debris, and he would make mulch, and he would sell it. Who's he selling it to? Has he done anything for this town? Has he really made any money for the town? The only money he's making is in his pocket. How come he didn't supply the town with mulch and loam and compost when they were putting the new school in, the new fire department in, the new just safety place up there? I never saw his trucks go in there once to help out the town. Where is he helping the town? He's destroying the town. All these people are sick of the smell, and I'm the only one that will go against him because I'm the only one has got the rights to go against him. So you hear the rest from the other people. He is running an illegal, rotten business, and the town is going to end up spending money to clean him out of there. Thank you for listening to me.
You're welcome. Yes, ma'am.
Hi, my name is Christine Nielsen. I live at Stockbridge Road also.
What number, two?
106.
Okay.
As far as her standing goes, isn't being a member of a community standing enough? Does she have to live next door to what's going on? She uses the road, she enjoys the river, the beaches, everything. She's been here forever and a day. She just informed you. She was on the beautification committee, volunteered for 8 years. She cares deeply about this town. That's her standing. It doesn't matter if she abuts or not. And there are abutters here. I dare you to listen to them, please, with an open mind. I'm incensed by all this. I respect him and his decision, I really do. I don't know, he was very straightforward. I'm kind of angry, and I'm kind of, think you're biased. I would go so far as to say you're customers of Go Green and that you bring your yard waste there. But I get it. I get that you're a zoning board and that this is very complicated as he presented very eloquently. He's done a great job for my mother-in-law. And I saw that you paid attention, ma'am, and I really appreciate that. And I literally mean with all due respect, I think this is bias, and I think you're customers of his, and I know that her intentions are very sincere as a member of the community of Scituate. Thank you.
Let me just address one of your things. First of all, I assure you I'm not biased. Issue of standing, one of the most difficult things about being a member of a zoning board is there are a lot of legal issues which have very specific meaning, and standing is something that is not always easy to maybe perhaps describe, and the cases are all the way up to the state Supreme Court describe what standing's about. So it doesn't surprise me that you and maybe others don't really understand what the issue of standing's all about. But if that was if just being a member of a community could bring a person standing to oppose a decision by the zoning board, it would be kind of a real mess. It's a legal issue. It's probably not an issue that's going to get decided here today. And if Mrs. Nielsen decides to appeal, well, first of all, we don't know, we haven't taken a vote yet, so I can tell you that. But I rest assured, I have no bias. I have no idea. I don't drop my yard waste off anywhere. I've got an acre and a third, and a lot of it's just in the hole in my yard type of stuff. And I come by my house. I don't have any mulch, I have to admit. But yeah, I'm not, I think doesn't the Green Connection sell mulch?
I don't think that I'm certainly not qualified to answer that question.
Your mother-in-law, I mean, I don't know. I might have bought
I'm not qualified
mulch
to
from.
answer that question.
Yeah, I have
This
no
is about
idea.
that,
I couldn't
with all
tell
due
you.
respect.
I have bought mulch in the past. I couldn't tell you who I bought it from. I can, please rest assured, there is no bias there.
Madam Chair.
Yeah.
I actually take offense that you're suggesting that there's bias.
Apologize. that
Yeah,
you're
no,
being
let me
frank.
please make my point.
Certainly.
If volunteering on boards is any standing in the town, I've served 6 years elected to the school committee. I've served on this board for 18, 19 years. I have given my efforts for the town. I have been a customer of the Scituate Playhouse, Raymond's Paints, Welch Company, all of which were projects that came before our board, which I sat on, for the use of those projects. I will freely disclose that I have purchased mulch from Go Green on 2 occasions, and I have brought a small amount of yard waste to Go Green because I too am fortunate enough to have an acre of land, and I have a pile in the back of my lot of leaves and yard waste, and that's where I put my yard waste. When I was speaking of Go Green providing a service which the town used to provide to the citizens of the town, that and apparently, according to Mr. Nielsen's previous testimony, in his statement, the town sought to contract this service out because he said he'd bid on it. I believe he said he bid on it with Mr. Lopes, or maybe perhaps against Mr. Lopes. I can't quite understand that, but that's not certainly before us. But it clearly appears that if there is an issue here with this operation on this property, as leased from the town, the issue is to address it with the town. And it certainly sounds like, based on the first 3 representations I've just heard, that there is some sort of a very serious disagreement between the applicant in this case and her family and the individual whose operation is being questioned. That's just an observation on my part.
Well,
And I am also familiar with the police records that were cited by the chairman, and I don't think it's appropriate to go into them in detail, but they are public record, and it is clear that the Scituate Police Department, on many occasions, have been involved in helping to mediate some sort of an ongoing dispute.
Again, I would contend that her simply being a very caring and concerned, much like yourself, a member of this community is standing enough. But I thank you for your time very much.
Thank you. Yes.
Hi, I'm Louise Benning. I live at 74 Collier Road. I think that if this is more of a personal dispute and Mr. Lopes isn't breaking any laws or like violating any of his rights, then I think this is kind of just like a nuisance between each person. And I don't think it's necessary to have like a big argument over this.
Thank you. Anyone else wish to be heard? Yes, sir.
My name is Mike Benning, and I live at 74 Collier Road, and I'd like to voice my opinion in support of Mr. Lopes and the business and the stance that the board seems to be taking here. I don't believe that this business is in violation of any codes or any lease agreements that they've signed with the town. I like to support the town businesses. and I do support Go Green, and for the simple reason that I like to support the businesses in town. Mr. Lopes is an upstanding member of this community. He coaches basketball teams, youth basketball teams. He's involved in a lot of youth programs. And for that reason, I'm in support of supporting Mr. Lopes and Go Green.
Thank you. Anyone else? Yes, ma'am.
Cynthia Newman, 200 Kent Street, and I'm a trustee at the Woodside Condominium Association. And I
Which condominium association?
Woodside Condominium Association, which is between New Kent and Kent. And on behalf of them, we just want to voice our complaint about the smell. I don't understand how that's okay. It is objectionable to the nth degree all summer long. In fact, yesterday it was not a very warm day. The smell was horrible again. I wish someone else would talk about the smell. In fact, that was one of the objections to putting the senior center somewhere near there, the smell. Also, there are flatbed trucks lined up down New Kent, all hours of the night, idling to be loaded up with whatever it is they're selling that stinks. Those trucks have ruined the landscaping, all the nice green berm that was set in place in connection with the bike path and all. So that was ruined, and it's been ruined, and it's mud out into the street. So whether it's legal or not, they're a big mess. So clean up your act, clean up the air. It's too high heaven.
Excuse me, ma'am. Please don't address your.
I'm sorry.
You're addressing your comments to these people who were in support of
no.
it. You had your eyes directly on them. They are just.
Okay, well, I'm done.
Just address it to here. I'm willing to listen to everything you say, but this is where it belongs.
Thank you very much.
You're welcome. And I understand. I used to have an office directly across the street from the town pier. Summers were not always pleasant, so I get the smell issue, but I think some of these
The town pier
issues-
has a fishing odor
Oh,
that
yeah,
is
big
part of our town,
I
so.
don't know what it is, though. What are we smelling?
Yeah, well, you're smelling piles, I don't know.
You could-
And
and the sewage treatment plant.
And Attorney Middleton, I mean, one of the things you commented on several times, there are all kinds of violations of DEP. My suggestion is, if you think that's I don't know. I mean, I don't know if you file complaints with DEP or what you do, but I haven't seen any kind of an expert report, and if you had to go into court and proved violations of DEP, the judge would look at you and say, Attorney Middleton, what do you have for an expert report that shows that? So these are all potential issues for you, and if you've got violations of DEP regs, DEP will listen. So I don't know, Conservation, Board of Health, I don't know where it lands, but, I'm having a tough time.
I guess just so you understand why we started here, this is kind of the first stop.
Sure.
It's a zoning issue out of the gate, and then we'll see where it goes from there, but we agree to disagree on the point that if it's not an overlay, then I think it was more of a zoning issue, because it violates, at that point, all this usage is in complete violation.
Okay, sir.
My name is Mark McKeever, and I am the abutter next to Mr. Lopes' organization.
What's your address? Did you give your address?
Yeah, 151 Driftway.
So when you abut, where are you
I
exactly?
am right next door to his facility.
Okay, so
To the left.
to the left?
House is set back about 210 feet, and that's my family's property.
Okay,
Just to give you a little update, my family has owned the property next to Mr. Lopes since 1941. I built a home there 10 years ago. I grew up there. I spent my summers there. I ended up building a very nice home for my wife and my two children. Mr. Lopes came in, obviously, next door. With the day he started to grind his yard waste, I've not been able to go outside. My children have not been able to go outside. My gutters have been clogged. My windows, I cannot open anymore because of the smell and all the debris there. I've seen, I can't even tell you how many times from traveling from Hanover to Scituate. He has another facility in Hanover that he's bringing material from the town of Hanover to the town of Scituate, which to me is absurd. I've had a number of discussions with Mr. Lopes, who we've had our ups and our downs as far as what's right and what's wrong. My gutters have been clogged when it comes during the snow season. I've had all kinds of issues with flooding and whatnot with my property. You know, I understand he's providing a service for you, for the town of Scituate, but, you know, in the grand scheme of things, you know, I think there are some flaws that should be addressed, in the sense that, you know, a lot of the runoff that goes down after the fires, I can't even tell you how many times I've called the fire department. I've been woken up and see the facility on fire, and with my kids waking up in the middle of the night trying to go to school, and having the fire department there at all hours of the night putting out fires. You know, they have to do their job too. And you know, the height of the material, the ground material, is, I think, a huge issue. And I really don't see much material getting brought out of there. I see everybody bringing their material there, which is great. But if he's providing a service, like as Mrs. Nielsen had said, he should be giving the town mulch and giving the community loom, giving back to the community if he's providing the service. And to me, all that those two big giant piles are just rotten, decomposing material that really is only going one way, and it's going into the marshland and contaminating the marshland.
Did you get notified?
I've never been notified. I was never notified. You know, I went to Tim the first time that he started to grind, and the wind was blowing to the east. And I can say my house has been built 10 years. I've never been able to open my windows in the summertime and enjoy the nice salt air that Scituate has to offer, because of the smell and the debris. I mean, if you go to my house right now, you open up one of the sashes and it's covered in dirt. And that, to me, why do I have to clean that? That's not my responsibility to clean dirt that he is. And I've called I've talked to the police a few times, and I understand there's a huge gray matter there. I get it, but I'm just trying to, inform you that, he's not all hunky-dory. I coach basketball, youth basketball, I coach football in town, I volunteer, I don't want to get into it. My family's been around here for a long time. And whether it's right or whether it's wrong, that's not my response. That's not what I'm here to say. But what I'm saying is that something needs to be done, and something needs to be done sooner rather than later.
Well, I hope that, certainly it doesn't sound like it's a dead issue, right, Bob? That there are ongoing concerns being addressed by various other town boards, correct?
I don't know if they're being actively addressed at the moment, Sarah, but certainly there's conversations about these issues.
Also, unless it's already been extended, and I'm not sure that it has, the lease is up. It's not up until June of 2019, but the lease is up. Speak to the selectmen, speak to the town, make your own, which sounds like you have some very valid complaints about the town's decision to lease that land for that purpose, and there's a group, the group should speak up, and that's a valid conversation. If the town doesn't want to extend that lease, the citizens that don't want to take that route should speak up, and there's an avenue for them to do that, and the town has every right to make a decision to not extend that lease.
Or to find the tenant in violation.
Right.
Yeah.
That
as well.
He is paying over $72,000 a year. So to say that the town is not getting anything out of it is As high as my taxes are, I'm telling you, they're
My
not
last-
$72,000 a
My
year.
last point would be, is that he's doing us a great service, obviously, but the amount of money that was lost, or we had a water ban, I mean, every night in the summertime, I go to bed and pray that that thing doesn't go up, because it's coming. When we're in a water ban, does he pay for the water that's used, or in the fire department's time or whatnot? Or I know they had ruined some fencing down there, and there's a lot of concern for me in the sense that obviously water is a huge issue, whether it be, sewerage or water that we need to take showers and do our laundry and our dishes with. But, 2 million gallons of water, that's a lot of water.
It is, and they probably pay the same amount towards that water used to put out any fires that you would pay if your house was on fire and the town came in
But
and
don't you
put the
think that's
fire out.
unnecessary? In the sense that
You want it to burn, just keep burning?
if I didn't call the fire department, it would have
Well,
continued to burn.
You know?
You make some valid points, and I sympathize with you. Obviously, you have great proximity to it. All valid points in a discussion of whether or not the lease should be renewed. Absolutely. Some of the other things, the ancillary services that he's providing, which may be outside the lease, those sound like discussions on whether or not they're in violation of the present lease. So that's another issue. But, it sounds like the group, and anyone else who wants to join it, has some very valid points in a discussion of whether or not the lease should be renewed. It seems like it's a long time away. It's not that long. This isn't necessarily a forever issue for you.
It'll never get through the Superior Court in a year and a half, I'll tell you that.
Well, yeah.
That's for sure.
Just follow up one point, Madam Chairman, on the water, just for the purposes of the record, I did ask for any and all payments made by Go Green to the town for any water usage, and the answer was none, just so you
Yeah,
understand.
I don't think this town, if you've got a fire at your house, if Mrs. Nielsen had a fire at her house, if any of you out there had a fire at your house, I don't think you get a bill from the town for the water used to put your fires out either.
Well,
There are
it's-
some communities, I think, that do that. I know that then some national parks, if you veer off the trail.
Fires created in violation of some statute or building regulations, absolutely. And I think maybe even this town would take that position, but, that's not something we have any power to impose.
Right.
No, no, I just,
So,
it came up, so I figured
I'm
I'd...
not sure I want
Yeah.
to go down that rabbit hole.
I
Just
don't.
one more, and now this will keep it brief. With that being said, he had a fire hydrant installed right in front of his facility just for that, because the first fire that he had, from what I was told, the fire hydrant that's close proximity to my grandmother's property, they had to run all kinds of lines. They didn't have enough connections to put the fire out.
Can I ask you to clarify that? Did the town ask him to install a fire hydrant and he
Correct,
paid,
did.
and he paid to do
And he
it?
did pay for
Okay.
that, which I...
That sounds
I
like,
give him 2 thumbs
sounds
up
like a
on.
good plan.
But on the flip side of that was, after the fire hydrant was installed, I had asked him, there was a period of about 4 days consecutively that he was grinding, that my house was covered in dust and dirt and debris and everything else, and I had asked him, why can't you hook up a hose that, where this process is running, that you can spray some water on that to obviously keep the dust and debris down? And he said, no, I couldn't do that because I couldn't pay for the water bill. Well, that to me that's crazy. You're hurting, my family and my children and anybody that wants to come to my house and enjoy my yard and my space that I own. We own 5 acres of land over there, and I can't go outside. That's crazy to me. How can I tell my daughter's, good girlfriends, oh, we can't go outside today because he's grinding and you can't go out and play. When it's 80 degrees out, oh, go read a book or go on the computer? That's crazy.
If I didn't make the point clearly enough, I apologize, but the whole point of bringing up the water was kind of to offset what Madam Chairman said about the fact that he's paying $72,000 a year, like this is a a big number and a big windfall for the town. But when you offset that with, $100,000 and more of water usage per year, it becomes something of a negative. There really is not much of a positive, and I know this
I'm not
isn't...
getting into numbers for you because nobody's provided us with numbers. So, the whole numbers game, the only number we have that he does pay, he pays significant rent. It's not like he's getting this $4,000 a month,
Even if you did provide the number, those sound like very good reasons why the town should reconsider the lease.
I get we're kind of conflating back and forth on lease versus zoning, but it's, they're all interrelated, I thought, with respect to the zoning board's decision on interpretation of the bylaws and...
Anyone else before we'll just hear from him. We'll hear again for you, Mrs. Nelson, later.
My name is Russ Paulin, 24 Vinyl Avenue.
And can I just ask, where is that in relationship to this property?
It's down near St. Mary's.
Oh, okay.
Yep.
Next street from me,
Okay.
Jenkins.
Yep. So I just want to say, I buy my mulch and my soil from the Green Connection. I deliver my organic waste, my leaves and all that other stuff to Go Green. I like them both. I think they both provide a service and a convenience to have them here in town, so we don't have to have stuff trucked in from all over other places. I consider the fact that we have this ability to be able to drop that stuff off there to be a gem of an advantage for someone living in this town. That's all I want to say. I just think it's something that we need to have, that kind of a facility one way or the other.
Thank you. Attorney Middleton, I took a note here. I said,
Sure.
Is it your position that mulch, the operation of Go Green creating mulch would not be allowable in any district in Scituate?
I guess you guys would know that better than me. I couldn't find an enumerated...
I'm asking you, you said it.
I didn't find it in the usage section of 400 where there's, they outline all these potential uses, so I would assume just because it's not there, maybe you need a permit, or how about just a permit? I mean, we've talked about trailers and this, I mean, I'm, as you pointed out, I'm not really zoning first, but...
You've done a fine job for your client.
But the idea that all this has taken place without a single permit being pulled, not a building permit, not a permit for a trailer, which you pointed out under 450, you need a permit for a trailer. Even if you want to...
I'm not doing anything, I don't know
Even a
that.
permit if you're building, an
Yeah.
architect can have put up a temporary trailer for 6 months, but I'm assuming he needs a permit to do it. Someone is okaying the conduct. This is one, I don't know if it's unusual, but there seems to be absolutely nobody monitoring what's going on in this parcel of land, and it appears that the
There's
reason...
a lot of people monitoring
Well,
it.
the citizens,
A lot.
yeah. But the...
Yeah,
you
this
know,
is good.
And the problem is, well, the town signed a lease,
Right.
but, yeah, my opinion, my presentation is, well, the town signed a lease to violate their own bylaw. That there's nothing,
We're not going that the bylaw has been violated. We're going that the lease may be being intensely utilized. Is if you, as an attorney, if a leaseor and a leasee have a written document, and the leaseor feels that the leasee is over intensely doing the use that was allowed, is it not the leaseor's responsibility to enforce the lease, or option to enforce the lease?
no doubt about it. I mean, I think
So the town has a right,
should be doing something.
they have a right to enforce the lease if they investigate it and find that they feel that the intensification of the use here is beyond the terms of the lease. That sound legal enough?
That sounds pretty good.
But that's why we figured we would start right or wrong with...
I'm a middle school teacher, but I've been doing this for a while.
Was your dad a lawyer?
No, he's a builder. He's a developer.
That's right. Mrs. Nelson,
Could I just add?
you may add anything you'd like.
Thank you. Does he need a permit now to run a roll-off rubbish out of that yard?
You know what? That's not an issue for me. I don't have a clue.
It's called Green Tree Block, and he has roll-offs coming out of the yard and picking up rubbish and dumping it there. Is he approved
Yeah.
for that?
I don't
So
know
no,
anything
no,
about it, and that's not an issue that's in front of us today. You can go see Mr. Vogel again.
I'm not sure I can adequately deal with that myself, but I'd be happy to investigate who could.
So, all right, would anyone else like to add anything new? First of all, I want to thank everybody who's here tonight. It's always great to have people interested in what the board does. It shows an interest in your town. I think you've all been very respectful. I know this is a very hot issue, very emotional issue for some of you, especially people who live so close. And again, the board appreciates it. I know that you have, handled your, your concerns and your complaints so well, so we appreciate it. With that, we'll close up. Do you have anything else to add?
There's another gentleman.
Oh, one more, sir.
My name is Stuart Kelly. I live at 56 Moorland Road. Moorland Road is across from Go Green.
Third Cliff.
I guess I have a challenge for the zoning board of the letter of the law and the spirit of the law. There's a big marsh that many of us live on. We're constructive abutters of the wind turbine, of Go Green, of the Scituate Country Club, but because of the big marsh, we're not actual abutters. So we don't get notice, we don't get standing, but we get to enjoy the sewage treatment plant, the wind turbine, Go Green, Scituate Country Club, and whatever else the zoning board chooses to allow there.
Oh, don't blame us all completely. Planning board's in on this.
Okay, but all I'm asking for is the respect of being treated as an abutter, because constructively we are. We have a big marsh there that we don't own, but the next property to us are these properties.
Well, I appreciate your concern, and I certainly don't know that I've ever heard that term. There is such a thing with zoning as constructive approval if we don't act in time, but constructive abutters, I'm not aware it exists.
To be honest, I see your point, and it's a good one.
We didn't get a notification as abutters when you put up the wind turbine.
I see your point, and if I lived where
We
you
didn't put it
lived,
up.
I would have liked notification as well. Now, taking that into the practical realm, in a town like this, in geographical situations like you're raising, Annie would like the pay raise that would need to be made commensurate with her notifying constructive abutters, as you put them. Maybe it's not necessarily realistic. I see your point. The practice is what it is because that's the way it works. These types of appeals and hearings are on the town's website. They are noticed in other ways. I sympathize to that in certain ways you should get the same notification that someone who's across the street does. Unfortunately, that's not the way the rules and the regs are set up.
And arguably, Hummerock abuts that marsh as well, and basically, and they can look across and see the wind turbine. We have
It's a matter of distance.
No, I do understand.
We abut London too.
No, well, my point is exactly that. What we do when we notice, when we send out the green cards, it's to within a certain radius of the location, and you're beyond that radius, and it's not just whether you physically abut the property, but you have to be within a certain distance of the property to be considered for notice. What the practice is that Annie goes to the assessors and gets a list of abutters, and it's from 300 feet from the property, and that's it. the notification in the newspaper, the notification on the website are all intended to make the general public more familiar. The wind turbine is on the marsh. We had a 40B before us the other night that's going to be on the marsh, and I hope that everyone on the marsh has a opportunity to come out and see that, and I'm giving public notice right now that that hearing is continuing. I think the next time is the 25th of January? 25th of January. So as a constructive abutter on the marsh, please come out because it's going to be an awfully big
That will
building
be
on the
held-
marsh.
Yeah, that will be held at the public safety, the police station, the public safety building, if you're interested.
But I agree, I do appreciate your position.
Okay. Yes, sir.
I'm Edward Coble from 45 Gilson Road. One of your board members tonight made a suggestion that you could parse it into two. One is the subject of the lease, generating mulch. And I guess adding selling mulch to that is probably not a big step. However, the other commercial enterprises that are activities that are going on there, the selling of stone, firewood, etc., is clearly a subject for the zoning board to consider. And while his suggestion was that he would be interested in having a motion made to grant that the production of mulch and commercialization of it does fit the lease, I'd like to suggest the opposite. I think this board should consider the other non-permitted businesses that he is operating there in violation of his lease and the zoning board's rulings.
Thank you. Just to clarify what I said before, and I think maybe I didn't do a good job distinguishing, is I sympathize with the applicant that are perhaps finding or not finding that a yard waste composting facility violates or doesn't violate the zoning bylaws I can't imagine you coming to a better place within the town for that finding. Finding what does or does not violate the lease, I'm not of the opinion we have the authority to say that. We certainly don't have the authority to grant a lease of town land, and in that same regard, I don't feel that we have the authority to say what does or does not violate a lease of town land. And that's the distinction that I was trying to draw. Hopefully I just did a better job of it.
And if I could clarify, the lease agreement that I have a copy of, it was submitted to us, says that this agreement shall include the town of Scituate's request for bids, commercial yard waste processing facility, and contractor's proposal, copies of which are attached hereto and incorporated herein by reference. I don't have that attached, but we're just by the title, commercial yard waste processing facility and contractor's proposal suggests that there's more to it than just simply receiving yard waste and processing it.
Do you think that the granite that is the source of those paving stones comes from our backyards?
I don't know what is in that lease. I mean, in the bid, the request for proposals. It could, I'm not saying it does, but it could certainly say, and associated activities. I know if I go up, I've never seen it, have you? If I go up to 3A in Cohasset, across from the train station there is a landscaping supply contract. They sell mulch, and they also sell associated materials. I don't know if there's terminology in this. I do know that at least one other person who spoke this evening said that they bid on this project with the town as well. They may have some idea, but I don't think it's before us. So I'm just suggesting that we need to be careful. We need to have all of the information available to us before we can make any comments on that. And the best place to analyze this lease and whether it's being met, the terms of it are being met, is with the Board of Selectmen with whom the lease was made on the behalf of the town of Scituate.
Do you know if anyone was bidding against him for this site?
Mr. Nielsen stated to this evening that he bid on it.
I did bid on it, but as it says in the bid, you're supposed to go get your own permit.
Mr. Nelson.
Don't, excuse me, Mr. Nielsen, you didn't ask to be recognized. I was responding to a question from the audience. Do I know? And I said, I only know that this evening Mr. Nielsen said that he did.
Thank you very much.
Yes, ma'am.
Hi, Lorraine Covell, 45 Gilson Road. I think my comments are not necessarily about the lease and whether it is or isn't legal use. I think my comments have to do with the spirit, the aesthetics, the gateway to our community that is so charged in my heart, I think, to most of us. And I think it's a black eye. I mean, it's bad enough we have the windmill, sorry. Now we have this mud pit, okay? You can't get your car in there in the rain. You have to go to wash your car after you get there. In the summer, it's dust. It all spews out into the street. There's fires, there's leaching, there's all these things that I don't think as a community on a waterfront property, if you had to think of any place to site a facility like this, that one would say, oh, I know, we'll put this on waterfront property. I mean, call me crazy, but it's ill-suited and it's ill-managed. And I don't know what the lease particulars state, but there should be something about remediating things like dust going into someone's house. That's ridiculous. That's a health, OSHA, there's OSHA issues, there's health issues, there's DPA issues, there's all these issues. And, just in a nutshell, that should be open space to our community. That's a ridiculous waste of waterfront property. Thank you for listening. Welcome. Yes, sir.
I just want to add one more thing, and I'll promise this will be the exhaust. Mark McKeever, 151. In the height of the springtime and in the fall, obviously when the leaves fall and people are cleaning up their yards, there's very high traffic in there. You also get the landscapers from town that come in and obviously dispose of their yard waste is there as well. There has been a number of times where I've almost got into an accident because a lot of the landscapers will park their trailers right up on the sidewalk heading east, let's say, heading towards town. They'll park their landscape trailers one in front of the other in front of the other. And so if I was gonna leave my property, I can't see any vehicles coming east and I have to kind of creep out a little bit further. And it's been a number of times where there's almost been a collision. I have a 17-year-old son that just got his license, and I'm terrified to think for him to come up, and if some of these landscaping companies will park there. I've asked him a bunch of times, I've even asked the landscapers a few times, and obviously they're not taking my request to heart, and I've had to be a little bit more boisterous in that request, that they just don't seem to care. Obviously, they're ruining the walkway and the mud and everything, but someone's gonna get hurt and, or God forbid, killed at that spot. It's going to happen. It's gonna happen. And they just don't, and I understand he has obviously confined space there where there's not very good traffic flow inside his facility. I understand that. But, if the town could maybe give him a place for the landscapers to park their trailers to come, and whether it's 18-wheelers, whether it's landscape trailers, there's going to be, somebody's going to get hurt up there. And I would hate to be, God forbid, somebody in my immediate family, or God forbid, a resident of the town of Scituate.
Oh, absolutely, and my suggestion might be if you feel that they're kind of parking illegally,
It's bad.
call the police.
I've called the police a
Yeah.
number of times.
And
They've
if
gone
that's
and
what you
talked
have to
Tim,
keep doing,
and
you
Tim
have to
just
keep
throws his
doing it.
hands up and says, there's nothing I can do about it.
Yeah.
And it's, you could send a memo, whoever comes in, you could hand him a sheet of paper and say, you can park your trucks or park your
Yeah.
vehicles down here. It's one of these, it's not my problem. And I understand it's probably not his problem, but in the grand scheme of things, God forbid there's a collision that happens and then there's lawsuits and everything else, well, then it becomes a huge problem that we really don't need to have. All that you need is a conversation to say, listen, don't do this. They put some sawhorses there for a number of months, the police department did, and it was great. And then they took them down and they continued to park there. And mark my words, it will happen. It will happen.
Yes, sir.
Larry Howell, 36 Moreland Road, neighbor of Mr. Kelly's. Issue, point of information. Who's responsible for enforcing the lease? Who in the town? Where do you go? Who do you go to?
For enforcing what?
The lease.
I would assume it would be the Board of Selectmen, as far as I know.
Specifically, what agent?
Well, the Board of
The Board of
Selectmen,
Selectmen.
that's the town board that would do that.
And they negotiate the lease?
I don't know if they have someone negotiated on their behalf, but they are the party to the lease, I believe. The town of Scituate is the party to the lease and
Elected representatives.
represented by the Board of Selectmen.
I mean,
Would the town manager be,
the town administrator is the
administrator
notice address for the lessor on the lease. He or she would
Is
just
Al
change-
still there?
would certainly be
Well, until the
involved.
first of the year.
Okay, you got about,
Al Bangert?
yeah.
Yeah.
But it would seem they, on behalf of the town of Massachusetts, is by the town administrator, the leaseor. So the town of Massachusetts is the leaseor,
But the administrator
but
would
the
be...
town administrator signed the
Would be
lease.
would be a good point of contact.
This whole thing sounds like there's a little something about maybe overuse of the property or something going
Right,
on.
those questions about the certain lease, about the existing lease, would be questions for the town administrator and the Board of Selectmen, I think. And, and what I'm hearing from the audience tonight, ma'am, you made some great points, sir. Those seem like incredibly valid statements and arguments and points of view as to, hey, I'm part of the town. I don't think that renewing or extending this lease in this location is in the best interest of the town. It sounds like you have some very good
The
statements.
enforcement of the present lease would be important if there are circumstances arising that are
It certainly will.
noxious to the
Yeah,
abutters, true abutters or virtual abutters, whatever that type of thing. But also for the future, yeah.
yeah.
Thank you.
Okay. Can we close the hearing on this?
The public comments?
Yep,
Sure.
okay.
I have a question for my fellow board members.
Okay.
Do we have to find something here?
Well, this would be my preference.
Please, that's why I was
Okay,
asking.
my preference would be to take a two-part vote. One on standing,
Mhm.
but notwithstanding what we may or may, let me just suggest that, and you probably know this, even if you win on the standing with the vote, that doesn't prevent the Superior Court from determining
One way or the other.
one way or the other. But take one on standing and then make a second vote on the merits. I think we do have to vote. I mean, we have to vote to either.
If there's been an
to reject or
application, we
appeal. Right.
can't ignore it.
Right.
Well,
We have to support, I think it's just simple, do we
Do you
support?
support the appeal or not?
Right,
Well, but the applicant could also withdraw.
I'm
Because
not in favor.
but if the applicant doesn't withdraw, and we vote, and they're precluded from coming back to us again on the same matter for 2 years.
correct.
And I think that's fine, because I think this is not the place. We can't have a situation where every time we vote, and an applicant is displeased with our vote, that they come back with a slightly modified or, you know,
Right,
a
that's my
continued
concern.
situation.
Yeah,
So,
I
mean, I would be
would
kind of
tend to
happy to
agree.
vote, because I think it would put this avenue off the table. And if our vote is then appealed to the court, and the
Then
court
so be it.
remanded it back to us, then we
So
can look
be
at
it.
it again, but,
Sarah, I tend to agree with you. I think we make a finding on standing, and then I would suggest and would move that we make a finding on whether the yard composting operation, to use the language from the lease, is a violation of the zoning bylaw.
I don't think it should be that. I'm kind of, I mean, I thought Ed made a valid point that there is, within the lease, it leaves room for question whether or not that is. I just think we have to vote whether or not we,
there's
We've
evidence
done this.
sufficiently before us.
right, that we support that's what we've done before, haven't we? We support the denial of the building
Yeah.
inspector for enforcement.
Move to deny the appeal of the appeal. And-
Right.
And support the decision as presented by the
Right.
building inspector.
We don't have to then get into the rest of it.
Great.
Okay. All right, so, I don't know, I'd like to make a motion that the applicant has not shown that she has standing to bring the appeal. Do we have a second?
I can second it.
Okay, all in favor? Aye.
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 Okay.
It's close, but I do think
Yeah.
there's a challenge. It
Yeah.
appears to be an ulterior motive. And
Okay, so no standing. All right, so now, on the issue of whether or not to support the denial of the building zoning enforcement officer for enforcement of the, and I'm saying this wrong.
Move that we deny the appeal and support the building code enforcement officer's position on the request by Mrs. Nielsen for action.
Second.
Second.
All in favor?
Aye.
Thank you. We hope that you move on, figure out what you're doing here. Thank you.
Do we have minutes?
Let's go. Let's count.
Chit chat. You know, what do you want?
She says everybody feels like I do, but no, I'm the best person to bring it.
Yeah, yes. Do you want me to look at that?
Huh? I know I do. I do some of it.
Okay.
Andy, do we have minutes?
Of course you do.
Sweet.
Here we go. Ready?
I'm ready.
Well, it's.
November 17th, was it?
November? November 15th.
November 15th. Move to accept the minutes of November 15th as mailed and emailed.
Second? Yep. All in favor?
Aye.
Okay. Move to adjourn? Someone?
Sure.
Move to adjourn. Seconded.
All in favor?
Aye.